But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress? How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that was sent to me unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother, wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check or something.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying to be dismissed.
Which one do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that, based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
that's the only civil infraction.
I have numerous, I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yes, right.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
At the very beginning, the judge makes something extremely clear. Objections are not magic words. In court, you don't object just to express disagreement, you object to preserve an issue for appeal, and even then, it must be timely and legally grounded. The judge is already signaling that repeated interruptions will not be tolerated. This is a courtroom, not a debate stage. When litigants refuse to follow procedure, judges move quickly from patience to enforcement to keep proceedings orderly and fair.
So on the bottom of the tickets it says, if you fail to contact the court within this specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact the court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame to contact the court.
Mr. Crucell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give me, okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
once again, I'm going to draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
This exchange highlights a common mistake made by self-represented litigants. Filing motions without clearly identifying the issue creates confusion and wastes time. Courts require focus, one issue at a time, clearly stated, with legal support. The judge isn't being dismissive here. She's trying to narrow the discussion so it can be resolved efficiently. When someone jumps between swearing-in issues, defaults, and citations, the court has no choice but to slow things down and regain control of the process.
Okay. Which then, again, there was no dates. I had no nothing. I had no notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
Which I object to that because there's.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I object
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you...
Here, the judge explains an important principle. Responsibility shifts to the defendant once a citation instructs them to contact the court. The phrase contact court for appearance date is not optional. It creates a duty to act. Defaults don't happen randomly, they happen when deadlines pass without response. The judge walks through dates methodically, showing how the timeline works. This is a textbook example of procedural law overriding personal interpretations or assumptions about fairness.
Which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, there'd have been issues.
What money did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is, procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
I don't
No,
think so.
she never did. No one did. I
Sir.
explained in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt's $100. The second contempt's a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry, there's just been a lot that's been going on with this.
And I'm, the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right? So we started with, what motion do you want to talk about first? You said your motion to set aside the default.
This is a critical turning point. The court establishes that the default was already set aside, meaning the defendant actually received the relief he requested. Despite that, the argument continues. Judges are trained to recognize when a dispute no longer exists legally. Once an issue is resolved, continuing to argue it doesn't create new rights, it only wastes court time. That's why the judge expresses frustration here. Courts move forward based on what is procedurally true, not emotional dissatisfaction.
Denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions, you can appeal.
Absolutely.
Okay, hold on. I denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my
object. You can appeal.
motion. Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that
The contempt warning is not casual. Judges use it as a last resort tool to maintain order. Interruptions undermine the fairness of the hearing, especially when one party is prevented from speaking. The judge clearly explains the consequences, first monetary, then jail. This isn't intimidation, it's transparency. Everyone in the courtroom now understands the rules. Respecting turn-taking and decorum is non-negotiable, regardless of whether a litigant feels wronged or overwhelmed by the process.
After the end, I had that confirmation well prior to me even being pulled over. Okay, so then this officer seen me leaving my house, pulling off my dead-end dirt road, proceeded. Like I said, I even told him I've already had this. I've already used that system. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay? And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well,
Is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly.
When the judge denies the right to travel argument, she's rejecting a theory that courts across the country have repeatedly ruled against. The explanation is calm and direct. Disagreement belongs in an appellate court, not repeated objections. This moment shows how judges separate legal arguments from internet-based theories. The ruling isn't personal. It's grounded in settled law. The judge even explains the appeal path, reinforcing that the system provides remedies, but only through proper channels.
324.81122 as adopted by Huron Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, the defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no?
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do,